Welcome back, everybody, to our studies in the criminal law. This lesson is continuing talking about the various different elements of theft, the various different categorizations, or at least the various different definitions of the key and core components of theft. This lesson is going to focus on the idea of property. Now, property, of course, is something that we have to define as part of the Theft Act, which the Theft Act actually does, and we'll talk about the various different kinds of property, the types of property that can actually be stolen as part of the Theft Act itself. So we have really been taking our time looking at the various different aspects and elements of the crime of theft. We noted in the first lesson that essentially the definition of theft, as defined in Section 1 of the Act from 1968, essentially coordinates that theft is the dishonest appropriation of property belonging to another with the intention to permanently deprive them of that property. We've talked about what we mean by dishonesty, talking about the case of Gauche, talking about the case of Ivy, and talking about the case of Barton. We then looked at the idea of appropriation, what it means to appropriate. We talked about the case of Lawrence, where even consent to appropriation actually can still amount to theft, and also the interference of property, which is something that we discussed in the case of Morris. This lesson, as I mentioned, is going to talk about two elements, really. We're going to talk about what we mean by property, and then what we mean by property that belongs to another, which are two elements of the Theft Act's definition. And then finally, the final lesson on theft will talk about the intention to permanently deprive one of their property. So, following the legislation, the Theft Act, Section 4, Subsection 1, defines property as including money and all other property, real or personal, including things in action and other intangible property. A very, very broad definition. What we mean by real versus personal, of course, for those of you who have already studied land law or maybe studying land law in accordance and in conjunction with the criminal law, real property refers to realty, i.e. land. Personal property may refer to a variety of different things, but can also and most likely includes things like chattel, things like objects, so things that are tangible. What we mean by things in action, we'll get to in a second, and then what we mean by intangible property, we will also get to in a second. But for the most part, property just includes the vast majority of things. It includes pretty much anything. It includes money, it includes any other property, and it includes property which may be real or personal. It could be realty, could be personal property, it could be things in action, and it could be intangible property. So, generally, we are referring to a very broad and all-encompassing definition of property. Often the controversies and the trials and tribulations that take place in relation to theft don't really hinge that much on the definition of property. We can generally come to a conclusion about what the thing is, that whether or not it is actually property for the purposes of the Theft Act, because pretty much anything that we would construe and consider to be capable of being stolen will count and constitute a type of property. So really, where we're talking about the definition of property, where we're talking about the definition of theft, we're often focusing on things relating to, for example, the idea of dishonest appropriation, the idea of appropriation itself, the idea of intent to permanently deprive, all of which are elements of theft which are distinct and are more controversial, at least in most cases, than that of the definition of property. The reference to money, of course, refers to any type of money of any type of currency. That's very easy to understand. The rest refers to personal property as well as realty. Personal property can be any item which is tangible. So, for example, your phone, if that gets stolen, a TV, etc., etc. Very easy to understand. Realty refers to land, but there are exceptions to this in relation to Section 4, Subsection 2. We won't get to that in this lesson, but if you want an extra lesson on the exceptions to this in relation to land, do let us know, and maybe I'll do a members-only video or something on that particular topic. It's not that controversial, it's not that in-depth or detailed in terms of reference, but it might be a bit useful for some of you who may want that extra bit of information. The thing that is a little bit different, though, is this idea of things in action. What is a thing in action, and why is this something that can amount to a property for the purposes of the Theft Act? Well, a thing in action refers to the right of an individual to sue another for a particular thing. So the easiest and most common way in which we can exemplify this is the idea of debt. So if a person owes somebody else some money by way of debt, they're indebted to them, this is what we would call a thing in action. Theoretically, a person can be sued for this thing. And so as a result of which, this can represent something of property in relation to the Theft Act, because it is the ability for an individual to sue. It is a right to sue an individual for a thing. And so that's why we call it things in action. So really, that's it in terms of the definition of property as per section 4. A little bit more controversial is the idea of property which belongs to another. Okay, you might not think it's that controversial, but there are some little edge cases that might be quite interesting to discuss. When the property is appropriated by the defendant, it has to be property which is belonging to another individual. This does not, however, necessarily mean that the person to whom the property was stolen was the legal owner, just that it did not belong to the person who appropriated it. So the legal owner is not a requirement to have had the property stolen from. The point of this is essentially that where we essentially conduct our investigation is not on who is the legal owner of that property, but who is the person who appropriated that property. So your focusing and your inquiry is on that of the defendant rather than that of a victim to the offence. And so the result of this means essentially what we're talking about here is that so long as the person who appropriated the property is not the person who owns the property, then you are going to be able to hold that it is property belonging to another. So what we see here in the Theft Act, section 5, subsection 1, is that property shall be regarded as belonging to any person having possession or control of it, or having in it any proprietary right or interest. Simple as that. Let's think about an example which illustrates some of the complexities of this point. So in 1971, we get the Second Turner case. This was a case which involved the owner of a vehicle driving a car away that had repairs done onto it. So essentially, what had happened here is the defendant took their own car, the car which they owned, to a garage for the purpose of doing repairs. And the car was then left, after the repairs had been done, out on the side of the street, at which point the defendant then took that car away without paying for the repairs. So the question here is, well, this is actually the defendant's own vehicle, so to what extent can we claim that this was the appropriation of property belonging to another? Well, it was considered to be theft on the basis that they had not paid for the repairs, and so the car was in the possession and control of the people who had operated the garage, not the defendants. And so the result of this was because the repairs had not been paid for, it was the theft of those repairs. And so it can actually be the case that you can take a property that is owned by you and that it could still amount to theft, but only in these kinds of circumstances.